Hi, and welcome to this episode of Tackling Your Taxes series, What Federal Income Taxes Are Dischargeable in a Bankruptcy Proceeding. My name is Aisha Servaty, and I'm the director of Mid-Minnesota Legal Aid's Low-Income Taxpayer Clinic, where we assist taxpayers with federal income disputes. And I have here with me today Shanshan, who is a law clerk with the Low-Income Taxpayer Clinic at Mid-Minnesota Legal Aid, and she'll be giving the presentation. So I will turn it over to Shanshan.
Hi, everyone. Thanks, Asia, for introducing me. I'm Shanshan, a rising third-year law student at the University of Minnesota Law School. I'm very grateful for this opportunity to present a tax law topic that's hopefully useful for our audience. So as Asia said, today's presentation is about the dischargeability of taxes in a bankruptcy proceeding, and we will go through factors that's listed here on the page that will determine the answer to whether your taxes are dischargeable or not in a bankruptcy. So as we can see, the first factor is the type of bankruptcy you filed. Second, we will introduce what it means for a debt to be discharged. And the third question is, did you include the IRS on the schedule of creditors? And then we'll talk about the nature of taxes involved and how does that influence their dischargeability. And lastly, we will point to some helpful resources where you can get help with your tax issues. Okay, so let's move on to the next slide. Let's first talk about different types of bankruptcies. So bankruptcy proceedings fall under the Title 11 of the United States Codes, which is also known as the U.S. Bankruptcy Code. So different chapters are named after different sections of the code. Each chapter is designed to serve a different type of entity or different need of the petitioners. So generally, individuals who file for bankruptcy would file a Chapter 7 or Chapter 13 case. Chapter 7 is also known as a liquidation bankruptcy, designed for individuals and businesses who cannot pay their debts, and the proceeding of bankruptcy trustee, proceeding or bankruptcy trustee liquidates and sells their properties and distribute the proceeds to creditors. And then we have Chapter 13, which is essentially a repayment plan for individual with regular income and debts below a maximum limit to set up a plan to repay their debts over a few years. And then much less frequently, individual would file a Chapter 11 or 12 case. Chapter 11, known as reorganization bankruptcy, allows businesses to restructure their finances so they can continue operating, or it can also be chosen by individuals when their debt amount exceeds the maximum limit of Chapter 13. And then lastly, we have Chapter 12, which is only available for family farmers or fishermen. So that's why Chapter 11 or 12 are less frequently chosen. There are also Chapter 9 and Chapter 15, but they are normally not suitable for general public, general individuals, because Chapter 9 is for political units such as cities, towns, and school districts. Chapter 15 is for cases involving entities from different countries. So with all this in mind, please also note that the rest of the presentation will focus on taxability of discharge in Chapter 7 and Chapter 13 cases, because as we mentioned, they're most frequently filed by individuals. Additionally, the type of taxes discharged we will talk about will be income taxes, for which the rules for discharge are largely similar under Chapter 7 and Chapter 13. Okay, so moving on to the next slides. So what does it mean for a debt to be discharged? So normally in a bankruptcy proceeding, the bankruptcy court would order a discharge of your debts, which releases you from personal liability for those debts. As a result, you are no longer legally required to pay any debts that are discharged. But keep in mind that not all debts are eligible for discharge. So that's why we are having this conversation, this presentation, because there is a whole complex set of rules governing what is dischargeable and what is not. Another thing to keep in mind is that as a general rule, if your debt is discharged by your creditors themselves instead of the bankruptcy court, the IRS may treat the discharge as taxable income, which means you need to pay taxes on the amount discharged. The logic behind is because like you get to keep some amount of money you would not have owned if it's not for the discharge. That is like by definition an addition to your wealth and therefore taxable income. But discharge ordered by the bankruptcy court, which is like our topic today, is an exception to this general rule. Another exception is student loan discharge. There are also like a few other exceptions as well. So like keep in mind if you ever are discharged of any amount of debt, you may want to consult a tax attorney about the tax consequences of that discharge. Okay, then we'll move on to timely notice to the IRS. So when filing for bankruptcy, you need to list all your creditors on a schedule. You must include the IRS on that schedule to ensure that the IRS receives electronic notice about your case from the court within a day or two of the petition date. If you left off the IRS off the schedule, and if you filed a no asset Chapter 7 case, it is likely that it will not affect the dischargeability of your debt. Chapter 7 no asset means you had no significant assets for the bankruptcy trustee to sell or liquidate and distribute to the creditors. But if you file other types of bankruptcy we just talked about, not notifying the IRS in time may lead to the result that your whole tax debts are not dischargeable, even if some of them would have been, like if you filed in a timely notice. Okay, then let's talk about the nature of the taxes on the next slide. So first, pre-petition versus post-petition taxes get different treatment. Let's first talk about what does it mean by pre-petition or post-petition taxes. So pre-petition taxes are those arose before the date you filed a petition for bankruptcy. Similarly, post-petition taxes are those arose after the day you filed for bankruptcy petition. So as a general rule, pre-petition debts are potentially dischargeable, and post-petition debts are not. There are some like nuances to that, but one essential one to keep in mind is that any income taxes arose in or after the year in which your bankruptcy petition is filed will count as post-petition debts. That is because the debt is treated as rising on the last day of the calendar year. So even if you file your bankruptcy, say on December 31st of a year, your tax debt from that year is still considered post-petition debt and are not dischargeable. Okay, let's move on to secured tax debts. So the second consideration is whether your taxes are secured. A secured tax debt is a tax lien issued by the IRS. If your tax debts have turned into a lien before you file the bankruptcy petition, they are not dischargeable in general. So how do you know if your taxes have become a lien? First, you need to really continue ignoring and refusing to pay your taxes to an extent that the IRS thinks they don't have any other option than issuing you a lien. And to do that, the IRS actually needs to file something called the Notice of Federal Tax Lien, or NFTL, and they need to do that before your bankruptcy petition date. So if they file the NFTL after your petition date, it likely won't affect the dischargeability of the underlying tax debts. You will, after they file the NFTL, you will receive a notice from the IRS about the lien or you could find it through a public record research. One thing worth noticing is that a levy is different from a lien. So like a levy is what the IRS issued to take possession of your income or assets to satisfy the tax debt. On the other hand, a lien is a legal claim issued against your property to secure payment of your tax debt. So if your taxes have turned into a lien before a petition date, they are not dischargeable. But if your taxes have not become a lien, we will look at whether they are priority taxes or not. So on the next slide, we have if they are if they are priority taxes, they are generally not dischargeable. There are three ways for your taxes to be priority taxes. Therefore, like on the flip side, if your taxes are none of the three things, then they are not priority taxes and are dischargeable. You will have to meet all three of the following conditions for your taxes to be non-priority and potentially dischargeable taxes. The first is that the tax return for which the tax debts arose must be due more than 3 years before your bankruptcy petition date. So for example, if you filed for bankruptcy on June 1st this year, 2024, and from that date, looking back 3 years, which brings us to June 2nd, 2021, if your return was due before that, you satisfy the first condition. If your tax return was due like on April 15, 2021, that will give us more than 3 years. So you satisfy the first condition. But on the other hand, if you have requested an extension to file your tax return and push back the due date to October 15th, 2021, then that's like less than 3 years and your taxes are priority and non-taxable taxes. Then moving on to second condition, the taxes must be assessed 240 days before the petition date. So what does it mean when your taxes are assessed? That means the IRS has determined or calculated the amount of your taxes. You normally would receive a notification from the IRS after you filed your return saying that your taxes are assessed. The precise date of the assessment can be found on your IRS account transcript. Okay, so the third condition is that the taxes cannot be those that are not assessed and yet still assessable. Okay, that's very complicated. For example, the amount of your taxes can be pending in a tax court case, which is not assessed on a bankruptcy petition date, but it is still accessible. Then that in that situation, that tax debt fails the third condition. Okay, so to summarize, you need to meet all three conditions for your taxes to be non-priority and potentially dischargeable. Why did I say potentially? Because if your taxes are non-priority, there is still one last test you need to pass. On the next slide, that is, there must be no bad acts associated with your debts. Otherwise, they may still be not dischargeable. So when your taxes are non-priority, if there are following bad acts associated with that tax, it's still not dischargeable. Bad acts include failing to file a return, filing a return so late that it was submitted less than 2 years before your petition to the bankruptcy court, and third, filing a fraudulent return, and lastly, willfully intending to evade or defeat the payment of tax. If any of these happen, your taxes are not going to be dischargeable. And lastly, our last slide, if you have like tax fines or penalties, they are dischargeable if you satisfy any of the following conditions. So either that your fines and penalties are from a tax claim that is itself dischargeable, or that the event giving rise to the penalty occurred more than 3 years before the petition date. If you satisfy either of these conditions, your tax fines and penalties will be dischargeable. Okay, so to summarize, first, find out what type of bankruptcy you filed. And then make sure you listed the IRS on the schedule of creditors. If your taxes had turned into a tax lien before you filed the petition, they are likely not taxable. If it's not a tax lien, and then if the return from which the taxes rose was due more than 3 years from the petition date, if the taxes were assessed 240 days before the petition date, and if the taxes are not assessed and not assessable, then they are non-priority and potentially dischargeable taxes. Lastly, if your taxes are non-priority, but there are bad acts associated with them, they might still be non-dischargeable. Tax fines and penalties are dischargeable if the underlying taxes are dischargeable or the event giving rise to the penalty occurred more than 3 years before the petition date. Okay, I will now hand it back to Aisha, who will introduce help resources for taxpayers to get help.
Thank you, Shanshan. That was great. Some helpful resources that we have is, as always, the United Way 211, which is available 24/7 by calling 211 or texting your zip code to 898-211-STAR. The United Way is more than just a tax resource. There are plenty of legal services available and social services available by contacting United Way. So we always recommend people start there as a resource. And then some IRS and bankruptcy court websites. If you go to the bankruptcy court, you can look at bankruptcy basics. And then for the IRS, I just want to highlight publication 908. Which is the bankruptcy tax guide, where you can find more information there as well. And if you just go to the IRS website at irs.gov, type in bankruptcy, you'll get a search result as well for different resources and some of those that we've talked about today. And then if you have a specific question about your specific situation, you can call our intake and we'll see if we can help. Our intake is 612-334-5970 or 1-800-292-4150. And again, we can help with federal income tax issues. So if you have a question relating to this presentation, if you're looking at bankruptcy or the dischargeability of your income taxes, or if you have questions outside this presentation about another presentation we've given, or just tax issues in general, call our intake and we'll be able to assist you. So thank you for coming into this episode of Tackling Your Taxes with Shanshan and I, and we look forward to seeing you at our next one. Have a great day.